Is it possible to have charges withdrawn in the Magistrates Court? Here we'll explain the process in the Victorian court system. Only police prosecutors who handle criminal matters at the Magistrates Court or the Office of Public Prosecutions in the county or Supreme Courts can decide which charges they will pursue or withdraw. It is their case and it is up to them, but is decided upon evidence and through negotiations with the accused defense lawyer. Getting charges withdrawn is not open and shut. How the matter is handled will depend on the evidence, client's instructions and the expertise of the defense lawyer. Firstly, police often lay multiple charges in relation to the one incident. For example, in a single physical altercation, a person may be charged with intentionally cause injury, recklessly cause injury and unlawful assault. It may not be intended for all these charges to proceed. The process then allows for the defense lawyer and prosecution to work out which is the most appropriate charge, if any. The defense lawyer may negotiate with the prosecution that the more serious charges be withdrawn and the client may plead guilty to the least serious of the charges. A second approach is, if it is apparent the police don't have enough evidence or inconsistent accounts of what is alleged to have occurred have been given by witnesses, the defense lawyer may urge the prosecution to withdraw the charges. This effectively ends the court process and the charge. Thirdly, if the defense lawyer has reason to believe and can argue that the charge proceeding is not in the public interest, they can approach the prosecution on this basis. This can only be decided on certain factors. These factors consider things like the seriousness and age of the offense, the culpability and capacity of the offender, the attitude and capacity of the victim, or other factors that may include community protection, circumstances that may prevent a fair hearing, or whether a sentence has already been imposed that reflects the criminality of the current charge. Another instance where charges can be withdrawn relates to family violence. Sometimes the police are called to a home where there has been an argument and it can lead to a criminal charge. These circumstances often represent a very fine line. If there is a charge in a domestic incident and the allegations are not serious, a lawyer can request a family violence case review and ask that charges not be pursued based on the review findings. Getting charges withdrawn can also occur as part of a negotiation. Sometimes to settle a matter, the prosecution will offer to withdraw some charges if the accused pleads guilty to others. This is not often a given. If the prosecution have strong evidence for a charge, it is expected they will pursue it. An expert lawyer knows how and when to negotiate in order to get certain charges withdrawn and to achieve a settlement that is satisfactory to all parties. Finally, if there is an issue with the charge or how the charge is laid, there is scope to have the charges withdrawn. The law is a framework of rules and regulations. An experienced lawyer will recognize if a person is not charged within the required statutory timeframe or the informant failed to complete the paperwork correctly, including proper filing and service, and always check that the charges against their client were laid in accordance with the law. There are many factors to consider when thinking about whether charges can or should be withdrawn. Each matter is individual and unique and requires expertise and strategy. If you are charged, you should contact an experienced criminal lawyer to determine if there is scope for some or all of your charges to be withdrawn.